You create an original work, draft a contract, transfer the rights to your company, and apply the favorable 15% tax rate to the revenue. Then the clock starts ticking. Months or years pass between filing that tax return and the moment the government actually looks at the details. Then, maybe 3 years down the line, a tax inspector suddenly knocks on your door, disagrees with how you valued your creative work, and demands the money back, along with severe penalties. Operating under this standard retroactive timeline turns a tax strategy into a high-stakes, multi-year gamble. This creates a direct financial risk for creators because Belgian copyright tax law is dense, technical, and aggressively enforced. The rules are in a constant state of flux. Recent government reforms expelled software developers and the IT sector from the favorable tax regime, leaving businesses to justify past returns under a new, stricter lens. But a law passed in December 2002 offers a legislative alternative. It established the Ruling Office, an autonomous branch of the financial administration. Their proposition is to secure a binding legal agreement on the tax consequences of your strategy before you execute a single contract, effectively reversing the timeline. This pivot allows creators to obtain prospective certainty rather than enduring years of retrospective anxiety. Securing an advance ruling takes about 3 to 6 months and follows a specific sequence, beginning with the pre-filing phase. Pre-filing is an informal but highly structured dialogue. Before submitting an official request, you prepare a detailed dossier and test the economic viability of your strategy directly with an official from the ruling office. To make this work, you have to open up your entire business plan to the state. You present your contracts, your valuation methods, and the precise reality of your daily operations. This is a consultative approach, removing the need to act blindly and wait for a potential audit years later. Total transparency is the mandatory requirement. You provide operational details in exchange for an administrative guarantee. The ruling office evaluates these dossiers based on the demand for absolute coherence between the legal texts you present and the actual economic substance of your work. Over the years, they have developed rigid, profession-specific doctrines. They apply specific boundaries, like capping copyright remuneration at 30% of global compensation, leaving 70% as standard income. They also police eligible professions, recently excluding software and IT sectors from favorable rulings. But the binding nature of the ruling only protects you if the facts you submitted perfectly match your daily reality. If an inspector later finds you described one business model on paper but practiced another, the agreement is immediately voided. The ruling acts as a mirror. It provides a shield against future audits, but only if the reflection it captures is accurate to the facts. For a company director, pursuing a ruling is an exercise in cost-benefit analysis. The upfront costs are specific. You must submit to financial transparency, and you have to pause your strategy for an instruction period that usually takes several months. The result, however, is a binding, prospective legal agreement. Once signed, government cannot retroactively dispute your valuation or your tax status. As outlined in Chapter 19 of the Belgian Author's Guide, the rules governing copyrights are highly technical and subject to reform. Attempting to navigate them without a ruling is an unnecessary hazard. Securing an advance ruling is a specialized tool for locking in a financial strategy before a single step is taken. The contents of this video are for informational purposes only and do not constitute formal legal or tax advice. Consult with a qualified accountant or tax professional to evaluate your specific situation before making financial decisions. Managing these rules effectively requires combining the right administrative tools with expert guidance.